Have a seat. All right, we are back on the clock, and we have a new panel, and I will introduce them to you. To my right is Judge Rand Wallace, our newest member of the court. He joins the court from the circuit bench in the 9th Judicial Circuit, and so we welcome Judge Wallace. And also, as a visiting judge today, to my left is Judge Deborah Nelson, and she is a circuit court judge in the 18th Judicial Circuit, and she is visiting as an associate judge today, and we welcome you.
Thank you.
So we're going to begin now with the case of Michael Elijah WYNN versus the state of Florida, and each side has 15 minutes. And how much time would you like to reserve for rebuttal?
3 minutes, thank you, Jen.
3 minutes? All right. Let me write up something. Okay.
Good morning, judges, counsel. May it please the court, I'm Nancy Ryan, representing the appellant, Michael WYNN. Mr. WYNN was convicted below of attempted second-degree murder and ag battery. He appeals. We are asking for a new trial on both counts on the Fourth Amendment issue raised in the briefs, and failing that, a new trial on the attempted murder count on the jury instruction issue raised in the briefs. That jury instruction issue is that the defense asked for the lesser included offense of attempted manslaughter by voluntary act. The state's position was that it's not in the schedule. There was confusion at the time of both the trials held in this case that there was a hung jury at one time. There was confusion during both, at the time both of those trials were held, there was some confusion in the appellate case law whether attempted voluntary manslaughter was still a viable offense.
Let me ask you this. About a year before I believe it was one of the trials, the first trial, the Supreme Court had determined that the voluntary manslaughter instruction was erroneous.
Correct, Judge.
And I know that your client requested that that instruction as a lesser included offense. Was the court provided with a special instruction to read, given the fact that the standard instruction had been declared to be erroneous?
No, Your Honor. The state has correctly pointed out that no written request for the instruction was made. Our position, as set out in the reply brief, is that Brown v. State from 1968 in the Florida Supreme Court controls. In Brown, it was, I believe, a robbery trial, and the defense asked for the lesser of larceny. The judge said, no, I'm not giving that, just as the judge did in this case. He said, no, it's not a proper lesser, I'm not giving that. The Florida Supreme Court held that in the face of the state's argument that there was no preservation, the Florida Supreme Court held, well, he said he wasn't going to give an instruction. You don't need to find paper and pencil at that point to write out an instruction that the judge has already made it perfectly clear. It would be a futile act.
Given the fact that Judge Berger had said that that instruction was found to be basically invalid, the court may have, we don't know because it wasn't offered to him, but may have accepted an alternative instruction. None was provided. Is that correct?
That is correct, Judge, but I submit to you the record does not support that interpretation. If you read both charge conferences, which I have provided the court with, the court's position is that it's not a proper lesser. And our position is that the question never arose after that, just what the elements would be of that proper lesser, since the judge said, I'm not giving it at all, and the state had just argued it's not in the schedule of lesser included offenses. I think the correct interpretation of the record is that the judge agreed with the state that it's just not a lesser, or it didn't exist. There was some case law at the time to suggest that attempted manslaughter by voluntary act was not even an offense. I think the fair reading of the colloquy in both charge conferences is that the judge believed either that there was no such offense or that it was not on the schedule of lesser included offenses, therefore was not to be read, and that the case law, I believe, supports my position that just because it's not in the schedule doesn't mean it's not a necessary lesser or that it's not a proper lesser. And that is our position in this case, that the matter was sufficiently preserved under Brown. I'd like to progress to the Fourth Amendment issue, if I may, unless the court would like to further revisit the jury instruction issue.
I'll come back. I may have a question, and I'll come back to it.
Thank you, Judge. The Fourth Amendment issue is that the defendant, Mr. WYNN, was arrested and gave a statement after the police entered his apartment without a warrant, and that statement should have been suppressed. The trial court ruled that exigent circumstances were present to excuse obtaining a warrant. Our position is that the record shows that a warrant could easily and conveniently have been obtained. Judges, when I wrote the briefs, I assumed someone on the panel would have familiarity with the Daytona Beach geography. I don't know that I have that this morning, and I don't think opposing counsel will object or disagree when I tell you that the Justice Center is about a mile that way, and Big Tree Road's about 2 miles, maybe 2.5 miles that way. So a warrant, the judge found as a fact that officers were on the scene for 2 hours before entry. Judge further found as a fact that no one attempted to get a warrant. It's my position on Mr. Wynn's behalf that those facts preclude the conclusion that exigent circumstances permitted the entry because the case law is...
Was there, am I reading correctly that while the police were, I guess, watching the house, that there was another officer attempting to get a warrant signed, an arrest warrant signed? Did I read that correctly?
Nathaniel Williams, the detective with the Daytona Police, testified that he was back at the office working on an arrest warrant. But again, the record shows that 7 officers were on the scene with 2 hours at the scene. So our position is that even if the record supported the ruling that the circumstances were exigent, and I would vigorously dispute that if we're going to get there, but my primary position is that exigent circumstances can't save this arrest and this subsequent statement because the record affirmatively shows that the warrant easily could and should have been obtained.
Wasn't that the statement wasn't a confession, though, and it was backed up by defense witnesses at trial? Why wouldn't that be harmless error if we were to find that the statement should not have been suppressed?
Judge, I don't believe the error is harmless because I don't believe the state can meet its burden of showing that there's no reasonable possibility the evidentiary error affected the verdict. And that's what they got to show.
Hold on a minute, though. We have, as a result of the entering of the home, I believe the evidence that was seized was a cell phone. I don't know that it was accurately or specifically identified as a defendant's cell phone. There were car keys that I believe were ultimately identified as the defendant's car. Is that correct?
Yes.
And then we had the issue of clothing that was seized from the home. That's all that I recall that was mentioned. I don't know if the other judges on the panel have a different recollection or if counsel can further clarify that. And then we have the issue of the statements that the defendant made post-Miranda. As far as the issue of the cell phone goes, obviously we had prior to that, the interview was given by the victim and the victim's then boyfriend. There was an issue of threats made. Obviously, those threats were captured in the victim's cell phone. So that's the evidence that we're talking about that was significant enough to highlight in the briefs. Can you please address for me why that information does not amount to just cumulative evidence or evidence that the jury should weigh in their role as a fact finder and weigh, choose to believe who they are going to believe in this jury verdict, which ultimately they decided that they believed the victim and not the defendant, correct?
Yes, Judge. The statement was I believe all that came in at trial, actually. As far as the texts are concerned, they were proved only through the testimony of Shay Thomas, the woman in the case. The state produced 8.5 by 11 sheet of paper with emails on it, and in this sort of vaguely, elusive, loose texty language.
But also, you had the defense witness. And the defense witness testified at trial that placed the Mr. Wynn at the scene. The defense witness testified that I believe that Jones or the victim shot at Mr. Wynn and Mr. Wynn ran off, and that somebody else came back and shot Mr. Jones, but it wasn't Mr. Wynn.
Correct.
And basically, that's what Mr. Wynn tells in his statement. He basically says, I was there, I didn't shoot him, he shot at me, and then I ran off. And so given what Mr. Wynn's statement was to the police, even if it were to be, we were to say it was improperly obtained as, the fruit of that unlawful search of the home, isn't it cumulative? And if it's cumulative, the courts have said that that's harmless.
Well, the state evidently thought that the tape statement was inculpatory because they introduced it. They didn't have to. They did. They relied on it twice in closing. They said this statement puts him at the scene, and at the very end they said you got to listen to this statement again.
I get that. We're error correcting. So it came in. Now, if we're giving it a harmless error analysis, and we're looking at what the jury heard, and it was what came in cumulative of other testimony and other evidence in the case.
The witness that the defense brought did testify to the story of the people coming and going in the shadows. One thing we know affirmatively from the record is that the jury was having problems with credibility. The jury hung the first time around. The jury was out 2.5 hours this time around. They sent out the question, can we please see the victim's prior statement? The victim and the woman in the case, Shay Thomas, both had prior record consisting of crimes of dishonesty. The victim and Shay both had a stake in the case. This was all a love triangle. That's how the shooting came about. As I was trying to get out before, the text and the letter were only authenticated by Ms. Thomas. They didn't bring anybody in from Verizon or AT&T, didn't bring in the police officer who allegedly typed them into that form in which they reached the jury. We don't know how credible they found Mr. Jermaine Jackson. We have no way of knowing that. We don't know how credible they found any of the witnesses. We have an indication by an affirmative indication, by sending out the question, by taking so long with what looks like an open and shut case on paper, doesn't it? We've got the surviving victim testifying that, yes, I know my assailant and I saw him pull the trigger. We've got Shay Thomas coming in saying these highly inculpatory texts came over my phone right afterward, and this letter which shows consciousness of guilt came a while later. That sounds great on paper until you look at this case, this jury, this verdict, and we don't really have a strong sense after analyzing the record. I submit to you that you should not have a strong feeling that the jury was behind all these witnesses. And we don't know what they thought of Jermaine. There was a little bit of self-contradictory statements flying around from the defense side. There were problems in the case, and it's the state's burden, I would just strongly emphasize to you, it is the state's burden to show one of two things. It's worded two ways in the case law. Either that there is no reasonable possibility that ever affected the verdict. That's the wording the Florida Supreme Court is using most recently. They also sometimes say it's got to be shown by the state beyond a reasonable doubt that the verdict was not in fact affected. It's two ways of saying the same thing. It's a steep burden. It's a strong burden, and I submit to you that given the jury's obvious difficulty with the case, that they have not met that, and I will reserve at this time.
Okay.
Thank you.
Wait 1 minute. Let me get you can come on up. Let me get the time right. It's okay.
Thank you. May it please the court, counsel. My name is Pam Kohler. I represent the state of Florida in this appeal. As for the first issue, I would dispute with counsel that the judge did not make his ruling based on the fact that of this case law out there from this court as well as other courts. In fact, on page 436 of the record report, page 8 of the, I think it's the supplemental, the first charge conference on June 20th, the judge said, over the defendant's objections, I will not include any lesser includeds under count 1, be it attempted voluntary manslaughter or agbat, and again, based mostly on those 5th DCA decisions. So that's the basis for his rulings, that we've got a ruling from the 5th DCA that says that this is fundamentally flawed. He said, and hopefully, I hate to have to retry cases, so hopefully we're right on that. Because of course, if they had given that instruction, I would have had to concede error on appeal. There would have been no doubt about that. I would have, especially since the Supreme Court affirmed this court's ruling in that case. That was relied on by the trial court during the first charge. The second charge conference, basically all they said was, we're going to rely on what happened previously. Now, if counsel had shown up 5 months later and said, Your Honor, we understand that you're ruling based on this first trial. Here's our jury instruction. We've amended a few of the words so that it is not fundamentally flawed anywhere. Would you please give this instruction? We don't know if the judge would have given that instruction. Or if they'd come in and said, we waive any Montgomery error, and we want the instruction regardless of whether there's error in the instruction. The judge might have given the instruction at that point too, but we have neither of those things. They just come in and just say, we want the same thing we wanted before, without any offer of a special instruction, anything to correct what was obviously, fundamental error. And we would be retrying at least that one count at this point in time because of that. So they gave the judge no choice in this thing, and that's why it's my position and the state's position, they had to come forward with a special jury instruction on this issue. As far as the third claim, the motion to suppress, we have several of the factors on whether or not you've got exigent circumstances. We've got a defendant charged with a very serious crime, attempted homicide. We've got probable cause that he's the one who committed it.
They waited there for about 2 hours, though.
They said at first they hung out about 100 yards. They were surveilling the area. They were waiting for sufficient forces to arrive because they had an armed man who had shot and attempted to kill some.
They also had a blind that they claimed was open, they could see in. They observed, after waiting there an hour and a half, they observed one person get out of bed, another person wiggle out of bed. So what were the exigent circumstances?
Well, they didn't see that until they actually approached the apartment complex. They couldn't see that from 100 yards away, which is where they had all gathered. At some point, they had stopped, they had seen one man leave the apartment complex, stopped him, found out he wasn't the defendant. I think they were just hoping he would come out, or they would see him coming to the apartment or leaving, and they could just grab him then. When that didn't happen, they finally decided they're going to go forward. And as they approached the apartment complex, that's when they actually see that the room number, D1, which is the one that the victim's ex-girlfriend, or the defendant's ex-girlfriend told him was where the defendant would be, they saw that the glass was broken and the blinds were broken. And that's when they started to get worried, and then, so they're knocking on the door saying,
Before
please.
that, I think there's a dispute as far as how they looked into the window. I believe law enforcement said they were able to see in the window because the window was broken and the blinds were broken.
Correct.
There's a dispute from the defense side that the only way they could have seen into the window was if actually they had manipulated the window blind to look in. But let's back up before that. Before that, even someone leaving, they interview the person, there's no, based upon what I reviewed, I don't believe it was exigent circumstances at that point. They didn't have any reason to believe that the people that were the occupants of that apartment were in any way trying to destroy any evidence, were in any way trying to flee the apartment. So at that point, we still don't have anything. What was it that triggered them to actually walk up to the apartment? Was it just the fact that they had been out there and had been observing the apartment for 2 hours?
Apparently a decision was made. I don't know if someone heard from the investigating officer who had finally gotten, the full statement from the victim's girlfriend, because she basically didn't come immediately to the police station. She said, I got to take my kids to school or take them home.
The state isn't contending that there wasn't sufficient time to get a warrant, are you?
No, I think they could have gotten in the 2 hours beforehand. I think that they were just going to walk up there and knock and try and, I think, lure the defendant out. They're knocking on the door saying, police here. They look through which the trial court believed the police officers that the blinds were broken, and of course, that was presumed to be correct as far as the facts.
But the hornblower case says that, suspicious movement, which occurs when police announce their presence, can't supply the exigent circumstances for the warrantless arrest.
Well,
and so, what other than the police coming to the window and announcing their presence, and then all of a sudden you see some people that I guess were asleep in bed, and then they get up and start getting out of bed. What other than that constitutes the exigent circumstances?
Because you have an armed suspect. I mean, the fact that he committed, a crime that is a very serious crime, that it's most likely that he's still armed. They find out that there's somebody else in the room with him, and they don't know if she's a cohort or if she's a hostage or what's going on. Again, they can't see everything because they are looking through the blinds the broken blinds, as opposed to just moving across and looking in. And they're basically yelling, police, knocking on the door, please, we need to talk to you, police. And they're just scrambling in there, and they don't know what they're doing. And so at this point, they do force entry. So I think the fact that you've got an armed suspect who, they didn't know if the victim was going to live or not, so it could be a homicide case. They see that these people aren't responding to their demands to come to the door, that they're the police, that they're not putting up their hands, that they're not coming forward. They see some movement inside. They can't see anything very clearly until actually the chief...
Can we move to the statement? The amount of time, I think it was either 15 to 17 minutes from the arrest to the police station, although he was Mirandized, I mean, it's not a very significant amount of time. So the defense has indicated that the burden is on the state to prove that that statement should have been suppressed, I'm sorry. Can you talk about that, please?
Well, I mean, he never confessed to anything.
But the statement was used in trial, and it was used in closing argument.
Sure, but again, I think it was harmless error at worst, because, I mean, we have the girlfriend testifies, look, I get these texts, and I look at them, and they're right around the time, I mean, these texts are sent right around the time that the victim in this case was shot, and they're basically like, his mama's going to be crying, and you're next. And, something about a T-shirt. And so she starts calling the hospital and finds out, guess what? Her boyfriend is, because she's afraid, because she knew that the defendant had stolen her boyfriend's phone. She'd been trying to get hold of him. She didn't want them to meet. And so she calls the hospital, finds out her boyfriend's actually at the hospital. He's been shot. And so basically the police then contact her, and she ends up telling them. And I guess the point, when the victim came out of surgery, he said Michael Williams or Michael Wim or something is the one who did this. And after, he was also able to pick them out in a photo array. So they have all of these facts that this is the defendant who committed it without going to the defendant's statement.
But if you're concerned for the safety of the victim, you have the victim at the hospital with, I'm presuming, law enforcement. You have the home where both the victim, well, at least the victim identified that as being his residence, surrounded by police. So at that point, you've removed what you believe to be the possibility of a future crime against the victim.
Well, he's an armed suspect. I mean, we don't know what he's going to do.
And even that, you have old information about whether or not he's an armed suspect, because you have, the apartment had been surrounded for at least 2 hours by law enforcement. He's not going anywhere.
Right.
If he had left the apartment, it would be a different case altogether. You agree?
Yes.
Okay. All right. And as far as when he shows up 15 minutes later at the police station, not only that, you have him half clothed, because law enforcement didn't even give him time to put on a shirt.
Right.
They just arrested him and took him to the police station in shorts, and we don't even know if he had on shoes, but he doesn't have a shirt on.
Right.
They had just pulled him out of bed.
Right.
So that is a short period of time, even though counsel for the appellant was talking about the locations here being in Daytona and how close by. I mean, that is a short period of time to be in bed, and then 15 to 17 minutes later, you're in the police station half clothed, correct?
Sure. But still, I mean, usually that's used because what happens is, because of those factors, they confess. They say, yes, I did it, that it just overcomes their ability to resist law enforcement, and they confess. In this case, he never admitted to shooting it. He never, ever admitted. And it was only when he was told, well, my ex-girlfriend told you about the text, and that the cops knew about the text messages, and the cops knew that that the victim had identified him as the killer or the shooter, and as well as her. It was only when he's told those things that he finally says, well, yeah, there was a shooting, but he shot at me. I don't know how he got shot.
But he did admit to the text. He admitted to sending the text, but he just said, oh, but that's a completely different issue.
Right, I didn't mean, and in fact, he did it in the letter, too. He then sent her a letter before she was going to be deposed by the defense, and said, this is how I want you to answer these questions. Well, if you're an innocent man whose text messages who meant what you thought they meant, then you don't need to be telling your ex-girlfriend how to respond at a deposition, which is, I'm not afraid of you. One, you've never threatened me or done anything to scare me. Yeah, I knew that you were just threatening to beat me and not kill me. All these things that he's basically telling her how to respond when she goes to her deposition. And the jury learned about that, too. They saw that letter. It was introduced into evidence.
If it's not significant, though, what he said in response to questioning at the police station, why did the state address that twice, once in their case and then on closing argument?
Well, it's certainly helpful to the state of Florida's case, but does that make it that the state could not have proven its case without this? Of course they could have. I mean, we had the victim coming in, and I mean, wavered from his identification of the defendant as the shooter. In fact, he comes out of surgery, and that's the first name. He's able to pick him out of a photo array. The girlfriend comes by and says, "It's Michael WYNN. I knew this was going to happen. You know, I was worried this was going to happen. Now it's happened. See my text messages." And the text came out right around the time that the victim was shot, because they began at 1:30 a.m. till like 3 o'clock in the morning. The law enforcement officer was called out to the hospital around 4 o'clock in the morning. So clearly, it's right around the time that the victim was being shot and attempted to be killed that he's sending these text messages to the victim's girlfriend. So I think all these things together leads to harmless error, that we've got more than, if all we had was the girlfriend's testimony or just the victim's testimony, it's a closer case, but we've got text messages that come out at the same time as the victim's being shot that are clearly threatening to the victim's girlfriend, as well as made her realize, the girlfriend realized, oh my gosh, something's happened to my boyfriend, I better call the hospital. I mean, she literally calls the hospital. It's not like she just, decides she's going to try and run over to his house to see how he's doing. She calls hospitals and realizes he's in the hospital. And she felt threatened herself, so the police also had to worry about any threats to the victim's girlfriend, too.
Well, let me ask you this. If we were to decide that going into the home was unlawful, was there sufficient separation between the search of the home and the statement because he was Mirandized and he waived Miranda, to dissipate any taint?
There wasn't a temporal break, I don't think there was. I mean, you certainly have only a few minutes from the time that he's arrested. And I think really he can only challenge the arrest, the illegal arrest. I don't know about the home, because I don't know that he actually lived there. I think it was the girlfriend's residence, not his own. But regardless, but I think you also have to show some sort of flagrant actions by law enforcement. And I guess if you want to find that going into the home because they think there might be something, there was a hostage situation inside the apartment, that was flagrant, then I guess we lose. But I don't think there was. I think you have to show that somehow it was overcoming his voluntariness of his statement too. You still have to look at the voluntariness of the statement. And he never admitted to anything, that he was the one who actually shot the victim in this case. He never admitted that, even though the cop asked him numerous times and confronted him with the evidence that the victim had identified him, the victim's girlfriend had identified him. We all know what's going on here, that sort of thing, and he never admitted to it.
So the state's contention basically is that even if the state did not use that defendant's statement at trial, there would have been a conviction anyway?
Yes. We had enough evidence. We had the victim always identifying the defendant, regardless of his credibility or not. He never wavered on that. We clearly have motive by the defendant as to why this man would be shot. We've got the victim's girlfriend saying, she gets these text messages, knows exactly who's done it. We've got the letter from the defendant to the victim's girlfriend telling her how to answer questions at the deposition. And again, as Judge Berger pointed out, we've got the defendant's own witness basically reaffirming what the defendant had told the cops in his statement. And also, another thing that has not been mentioned is that the defendant didn't have to testify because of this. In the opening statement, the defense attorney says, my client doesn't have to say anything more about this. He said everything he needed to in that statement. And he used that statement. So it wasn't just the state of Florida who relied on the statement, but it was the defense too. And because of that statement, they did not have to have the defendant testify and potentially be subjected to cross-examination, which, depending on how good a witness the defendant is, was certainly a benefit to the defense. So I'd add that also. And I notice that my time is run, so I rely on my brief on the rest, and please affirm. Thank you.
Okay, thank you. You have about 2.5 minutes left.
Judges, as to the attenuation question, I could not find it in my paperwork just now, but I believe the state conceded below that the taint was not attenuated. It was during the suppression hearing, they were having trouble with technical trouble, and I think they just threw up their hands and conceded the taint was not attenuated. In any event, the judge did rule that the taint was not attenuated, and I don't believe the state has shown sufficient grounds for this court to reverse that legal ruling.
Let's go back to the issue of the instruction, because the conference, charge conference, and the state mentioned it, and that's what I was looking for in my notes, about the judge making the decision not to give the instruction based on cases that he had been provided out of this court. And given that decision based on the case law, you don't believe that it would have been, that your client should have presented the court with a special instruction, because perhaps the judge would have given it had there been an instruction that was provided.
Judge, again, that's not my reading of the charge conferences, plural, and I submit that defense counsel could reasonably have relied on the Brown case as to his preservation requirements. And I believe that a contrary decision from this court would be inconsistent with Brown. And if I may return to the Fourth Amendment issue, judges, the issue is not what the state could have proved without the error. The question is what effect the error had on the jurors. The Supreme Court has made that very clear. In Ventura, case sending back to the second DCA for...
What about the state's argument just now that the defense itself relied upon the statement in its opening by saying that the defendant does not have to testify because the statement is available?
I don't think that meets the burden of showing that the error is harmless. We knew it was coming in. They said it was coming in. We had to deal with it somehow. It was the state's decision whether to bring it in. And our position is that it was error to bring it in. As to the harmlessness, I would rely on the McKeon case from this court cited in the brief at 13, and the Jackson case cited in the brief at 12. Those cases hold that this established that this court looks to the jury's questions during deliberations and looks to emphasis in closing argument by the state to determine harmlessness.
But as far as the weight and the strength of the evidence, you would agree with me that a lawyer who was going to defend Mr. WYNN during the course of his trial certainly would not have highlighted what would have been believed to have been very strong evidence in favor of the state, which would have been the statement. You would agree that the fact that the defense attorney at the beginning of the trial didn't have to say anything in the opening statement, but did make reference to the fact that you're not going to hear from my client because my client has already said everything that he needs to say to defend himself in that statement. So jurors pay attention to that statement. You would agree with me that common sense would dictate the defense lawyer's not going to highlight that if it were strong evidence to support conviction on behalf of the state.
Judge, my position is and he knew it was coming in and he had to deal with it somehow, so I submit to you that you can read that as bravado. And I believe my time's up.
It is. Thank you.
Thank you, judges. I ask you to remember.